Pick a number. How many times should a kind of forensic evidence be examined before a courtroom trusts it? 10? 1,000? Hold your number. It comes back at the end of this. In 2005, Congress directed the National Academy of Sciences to convene an independent committee and answer a question nobody in government had asked directly. Does forensic science work? DNA had been studied heavily. Almost nothing else had. The committee met 8 times across 2007 and 2008. It heard from federal officials, academics, law enforcement, crime lab directors, defense attorneys, medical examiners, and exactly one coroner. In 2009, it published 350 pages. The federal record number is NCJ 228091. This is what it found. Start with the thing that surprises people most. There is no forensic science system in the United States. There are thousands of separate operations with different funding, different oversight, different training, and different standards. The committee wrote that the enterprise lacks the governance structure to pull itself up from its own weaknesses. No professional society is dominant. No municipal or state office has the mandate to lead. The numbers. As of 2005, 389 publicly funded crime laboratories received 2.7 million new cases. More than 175 public labs and about 30 private labs do DNA analysis. But DNA evidence appears in only about 10% of casework. The other 90% rests on something else. And 2/3 of all fingerprint identifications happen outside crime laboratories entirely. In police identification units, nobody was counting. Then the backlog. The Justice Department defines a case as backlogged if it sits in a laboratory 30 days or more without a report. By that definition, federal, state, and local labs reported a combined backlog of 435,879 requests. Backlogged cases rose 24% in 3 years, from 287,000 to 359,000. Here is the first unintended consequence in the report. California passed Proposition 69, expanding DNA collection from felons. It was designed to solve more crimes. By the end of 2005, it had produced 235,000 backlogged cases in California alone. More collection, without more capacity, produced more delay. And a backlog is not an administrative statistic. The report states that backlogs can result in prolonged incarceration for innocent persons wrongly charged and awaiting trial. It states they can contribute to the release of guilty suspects who go on to commit further crimes. The director of the Los Angeles County Sheriff's Crime Lab told the committee how triage actually works. Homicides, rapes, and assaults get priority. Burglaries fall far down the list, which makes examination of property crime evidence unlikely. He also said police and prosecutors are rarely consulted on how those priorities get set, and that a persistent investigator who calls often enough gets their case done faster. Only 21% of laboratories surveyed reported having enough full-time staff to complete their workload. 51% outsourced work to private labs. And there is a published survey of laboratory directors the committee cites directly. As casework capacity increases, pressure to complete cases too quickly increases significantly. Pressure to extend opinions beyond the scientific method increases significantly. And pressure to get a particular result increases significantly. That is in the report. One more structural fact. Unlike other professions, the forensic disciplines have no organized control over entry, no required degree, no board exam, no licensure. Control has traditionally been exercised through employment alone. The committee describes a guild structure built on apprenticeship, with only thin ties to the research universities that would normally test its claims. The consequence, in the committee's words, the fragmented nature of the enterprise raises the worrisome prospect that the quality of evidence presented in court and its interpretation can vary unpredictably according to jurisdiction. The same evidence in 2 counties may not produce the same conclusion. Now the sentence the entire report rests on. With the exception of nuclear DNA analysis, no forensic method has been rigorously shown to have the capacity to consistently, and with a high degree of certainty, demonstrate a connection between evidence and a specific individual or source. Not fingerprints, not firearms, not bite marks, not hair, not handwriting, not footwear. The word at the center of this is individualization. It is the claim that an item from a crime scene can be traced to one source and one source only. To support that scientifically, you need two things: how much a single finger or a single tool varies from impression to impression, and how much it varies across an entire population. Those studies have largely not been done. Without them, the committee says, uniquely associated with has to become a probability, and other possible sources cannot be completely discounted. The committee also points out that courts have already proven they can handle this, because that is exactly how DNA evidence works, with a small but non-zero error rate, stated out loud. Most forensic methods have never developed a measure of how accurate they are. Some laboratory reports contain nothing but identifying information, a description of the evidence, the test requested, and a one-line result. No methods, no measurement uncertainty. ISO 17025 already specifies what a report should contain. Many forensic reports do not meet it. Then, human factors. The committee cites research finding it is possible to alter a fingerprint identification decision on the same print, solely by presenting it in a different context. And it goes further than the finding. It states there is no good evidence that the forensic science community has made a sufficient effort to address the bias issue, which meant the committee could not measure how large the problem is. Unlike medicine, where a wrong diagnosis eventually surfaces, forensic conclusions rarely get that feedback. There is no self-correcting loop. In 2004, after the Madrid train bombings, Spanish authorities sent digital images of partial latent prints to the FBI. Examiners searched them and linked one to Brandon Mayfield, an attorney in Oregon. Standard protocols, standard methodology. The association was independently reviewed and confirmed by an outside experienced fingerprint expert. Spanish authorities then alerted the FBI to information casting doubt on the finding. The Justice Department's Inspector General investigated. The FBI convened an independent panel. Both reviews concluded the problem was not the quality of the digital images. It was the bias and, in their phrase, the circular reasoning of the examiners. And here the report records something unusual. The field cannot agree on what an error is. Experts told the committee that if a declared match is later shown by DNA to be a mismatch, some practitioners dispute that the original call was an error at all. Some would not concede that there could be less than perfect accuracy in any laboratory or any discipline. Assertions of a 100% match contradict proficiency tests finding substantial rates of erroneous results. The unintended consequence of insisting on perfection is stated plainly. That insistence has hampered efforts to evaluate the usefulness of the disciplines. A method that claims a zero error rate has no reason to improve. Finally, the language. Examiners testify using the words match, consistent with, identical, similar in all respects tested, and cannot be excluded as the source of. There are no standardized definitions behind any of them, and no probabilities attached. The committee's finding is that these terms can and do have a profound effect on how a judge or jury perceives the evidence. So the committee went through them one at a time. Nuclear DNA is the benchmark. There are biological explanations for its findings. The 13 genetic markers were chosen so the odds of two people matching on all of them are extremely small. False positive rates have been quantified. Procedures are validated and proficiency tested. But note why. DNA is reliable because it was scrutinized, funded, and validated by outside scientists. It arrived from cutting-edge biology, not from forensic practice. Nothing else got that treatment. And labs still make handling errors, mislabeling samples, losing samples, misinterpreting data. Controlled substance analysis is a mature discipline built on classical analytical chemistry, with broad national agreement on best practice. One caveat: because the standards were written to work worldwide, they permit substituting a chain of simpler tests when preferred equipment is unavailable. The committee questions whether every permitted combination would be scientifically acceptable for an unknown substance, and notes the reports filed in court often do not say which tests were run. Fingerprints. The committee accepts that friction ridges carry enough detail that careful comparison can plausibly discern a common source. What it does not accept is the method. ACEV, analysis, comparison, evaluation, verification, is described as a broadly stated framework, not a validated method. It does not guard against bias. It is too broad to ensure repeatability. It does not guarantee two analysts will reach the same result. There is no requirement that an examiner document which features supported the conclusion. Two researchers who reviewed the scientific evidence for ACEV's validity reported finding none. The claim of a zero error rate the committee calls not scientifically plausible. In October 2007, a Baltimore County judge refused to allow fingerprint testimony in a death penalty trial, describing the traditional method as subjective, untested, unverifiable, and purporting to be infallible. Footwear and tire impressions. The premise is sound. Mass-produced items pick up wear features. But those features keep changing, so time works against certainty. There is no consensus on how many characteristics are needed for an identification, and the committee states it is not aware of any data on the variability of those characteristics or on the validity or reliability of the method. Which brings us to the number you are holding. A European survey counted how many times each impression discipline had actually been performed. 42 laboratories had conducted 28,093 shoeprint examinations. 41 laboratories had conducted 591 tire track examinations. 17 laboratories had conducted a combined total of 100 earprint examinations. And 14 laboratories had conducted a combined total of 21 lip print examinations. 21. The committee's conclusion is that it is difficult to assert the field has enough collective judgment about lip prints and ear prints based on tens of examinations, and that little, if any, research has been done on rare impression evidence. Tool marks and firearms. The governing standard permits an examiner to declare a match when sufficient agreement exists between two sets of marks. The meaning of sufficient agreement is not specified. The examiner draws on personal experience. The committee states the field's best available guidance does not even consider questions of variability, reliability, repeatability, or how many correlations are needed for a given level of confidence. Microscopic hair comparison. No accepted statistics on how common any hair characteristic is in the population. No uniform standard for how many features must agree. And an FBI study of 80 hair comparisons that examiners had declared associated found that 9 of them, 12.5%, came from different sources when retested by mitochondrial DNA. The committee found no scientific support for using hair comparison to identify an individual in the absence of nuclear DNA. It also flags the word associated itself as undefined and open to being misunderstood as individualization. Fiber analysis has standardized procedures and annual proficiency testing, but no threshold. No studies of fiber variability during manufacturing on which to base one, and no studies characterizing error rates. A fiber match means only that the fibers could have come from the same type of garment or carpet. Questioned documents. This is one of the few pattern disciplines where somebody measured. In testing of more than 100 examiners making 144 pairwise comparisons each, Professionals declared an erroneous match 6.5% of the time. A later signature study put professional error at 3.4%. To be fair to the field, examiners were substantially more accurate than laypeople. But 6.5% is a number, and juries are not routinely given it. Paint and coatings performs well as chemistry. Studies found more than 97% of automotive paint samples and more than 99% of architectural samples could be differentiated. But discrimination is not identification. Paint narrows the field. It does not name a source. Explosives residue analysis rests on well-established chemistry. Fire origin determination does not. The committee found that many of the rules of thumb long assumed to indicate an accelerant, alligatoring of wood, specific char patterns, have been shown not to be true. And it states that despite the lack of research, some arson investigators continue to make determinations about whether a fire was set. An accidental fire can become a criminal charge on a discredited pattern. Bite marks. The committee received no evidence of an existing scientific basis for identifying an individual from a bite mark to the exclusion of all others. There are no large population studies. There is dispute over whether human skin even reliably registers a bite. And in numerous instances, experts examining the same bite mark reached widely different conclusions. Bite marks appear most often in homicide, sexual assault, and child abuse cases. Bloodstain pattern analysis. Some aspects are supported. You can tell whether blood spattered quickly or slowly. But bullet trajectories are linear, while the damage they do in tissue and the patterns fluids make leaving a wound are highly variable. The committee's sentence is one of the bluntest in the report. The uncertainties associated with bloodstain pattern analysis are enormous, and digital evidence, the newest and fastest growing, where almost every crime could now have some. The technical procedures are sound. The people are the gap. There is no agreed certification program and no agreed list of qualifications for digital forensic examiners. The obvious question is where the judges were. Under the 1993 Daubert decision, a trial judge is a gatekeeper. Can the technique be tested? Has it been peer-reviewed? What is its known error rate? Are there standards controlling its operation? Is it generally accepted? Those are the factors. But the Supreme Court also called the inquiry flexible, and in Kumho Tire left it to the trial judge's broad latitude whether those factors even apply. And the court's stated remedy for weak evidence was cross-examination, not exclusion. Here is what the committee found in practice. In criminal cases, trial judges rarely exclude or restrict expert testimony offered by prosecutors, and appellate courts routinely deny appeals contesting decisions that admitted forensic evidence against defendants. In civil cases, the situation appears very different. Both sides are more likely to have access to experts, and appellate courts appear more willing to second-guess the trial judge. The committee cites scholarship concluding courts applied Daubert more lackadaisically in criminal trials, especially toward prosecution evidence than in civil cases. For structural reasons, this does not self-correct. Judges and lawyers generally lack the scientific expertise to evaluate the claims. Trial judges rule alone, often with little time for research. Appeals are reviewed only for abuse of discretion, a very narrow standard. And courts must resolve disputes finally and quickly, while science revises itself indefinitely. The report suggests some courts are loath to demand validation research that the disciplines could not presently provide. The committee's conclusion? The adversarial process relating to the admission and exclusion of scientific evidence is not suited to the task of finding scientific truth. Judicial review, by itself, will not cure the infirmities of the forensic science community. So who is watching? The laboratory that tests your blood at a hospital is federally regulated. About 189,000 clinical laboratory entities fall under that system. The laboratory that produces evidence to convict you is not. Accreditation is mandatory in 3 states: New York, Oklahoma, and Texas. Everywhere else, it is voluntary. Outside traditional crime labs, a survey found only about 15% of forensic units are accredited at all, and accreditation is not a guarantee. The report is explicit that an accredited laboratory can still make mistakes. Accreditation means the lab adheres to a set of quality standards, not that every case is right. Certification of individual examiners is not required to practice or to testify anywhere. Protocols, where they exist, are often vague and not enforced in any meaningful way. Codes of ethics are generally comprehensive, but can only bind the members of the organization that wrote them, and there are no consistent mechanisms for enforcing any of them. Few practitioners face a real threat of sanction for a serious ethical violation. Structurally, the majority of forensic laboratories are administered by law enforcement agencies, with the laboratory director reporting to the head of that agency. The lab cannot set its own budget priorities and competes with the police department for resources. The committee's position is that scientific assessment should be independent of any effort to prosecute a suspect, or even to determine whether a crime occurred. It extends the same concern upward, noting that the National Institute of Justice and the FBI laboratory both sit inside a prosecutorial department of government. There is one federal grant program that requires accountability. Under the Justice for All Act, a lab taking Coverdell money must certify that an independent external entity will investigate allegations of serious negligence or misconduct. The Justice Department's own Inspector General reviewed how that was working. Twice. The first review found the program announcements did not provide guidance on what an independent external investigation even was. The second returned and recommended rewriting the certification so applicants had to confirm the named entity actually had the authority, the independence, a process excluding laboratory management, and the resources to investigate, and that only complete certifications receive grants. Then there is the part of the report that gets the least attention. About 2.6 million Americans die each year. Medical examiner and coroner offices receive roughly 1 million death reports and accept about 500,000 for investigation and certification. That is 1 death in 5. Those offices decide whether anyone goes to the scene, whether the body is examined, whether an autopsy happens, and what tests are ordered. They are spread across 2,342 separate jurisdictions. 80% of offices are run by county coroners. Of about 1,590 coroner offices, 848 serve jurisdictions of fewer than 25,000 people. 82% of coroners are elected. Typical qualifications for the office are being a registered voter, meeting a minimum age of somewhere between 18 and 25, being free of felony convictions, and completing a training program of varying length. Coroners may or may not be physicians, may or may not have medical training, and may or may not perform autopsies. In one state, justices of the peace determine cause and manner of death. The report records that in 2007, a 17-year-old high school senior successfully completed the coroner's examination and was appointed a deputy coroner in an Indiana jurisdiction. It appears as an illustration of where the statutory floor sits. About 36% of the U.S. population lives where minimal or no special training is required to conduct death investigations. Whether a coroner refers a case to a pathologist for autopsy is described as largely budget-driven. An autopsy costs about $2,000. And 84% of coroner offices themselves told researchers they see a need for professional standards. Capability. Only about 1/3 of offices have in-house histology. Only 37% have in-house toxicology. 1/3 have no radiology. 54 medical examiner offices in the entire country are accredited, covering 23% of the population. Some coroner systems have no physical facility at all. Most autopsy facilities average 20 years old, and a third lack design or airflow control of pathogens. What that means in practice is listed in the report. Insufficient toxicology means unsuspected homicides, suicides, and child and elder abuse may go undetected. Molecular testing exists for inherited sudden death syndromes in young people, but most offices cannot afford it and lack the expertise to request it or the skill to interpret it. Testing for inborn errors of metabolism should be part of any examination of an unexpected infant or toddler death. Imaging would reveal internal bleeding, missile paths, and fracture patterns. Very few offices have it. Independence. 43% of the population is served by independent systems. 33% by offices sitting administratively inside public safety or law enforcement organizations. The report names the cases where that matters: police shootings and police encounter deaths, deaths in jails and prisons, deaths in public institutions. Those, it says, require an unbiased death investigation clearly independent of law enforcement. And it names the mirror image problem with coroners. They are independent of police, but as elected officials, they must be responsive to the public, which the report says may lead to difficulty in making unpopular determinations of cause and manner of death. None of this is new. Efforts to replace the coroner system in the United States date to 1877. In 1928, the National Academy of Sciences called for the abolishment of the coroner's office, finding it had conclusively demonstrated its incapacity to perform the functions customarily required of it. The 2009 committee's assessment of what happened in the 81 years since is 4 words. Progress has been very slow. Why it stalls? Some states would have to amend their constitutions or codes. There is a political constituent base underpinning local coroners. Small counties lack the population and budget, and the workforce math does not close. Since 1959, about 1,300 pathologists have been certified in forensic pathology. Roughly 400 to 500 practice full-time, against an estimated need of 1,000. Only about 70 fellowship slots exist each year, and only 70% get filled, because the average 2006 medical graduate carried more than $130,000 in debt, and forensic pathology pays less at entry than hospital-based pathology. One more consequence, and it is the kind that only shows up when you read the whole chapter. Medical examiners and coroners are legally responsible for the dead in a mass casualty event. All deaths from any form of terrorism fall under their jurisdiction. The committee found that outside a few large systems, preparedness is generally very low, and managing fatalities across jurisdictional lines, as Hurricane Katrina required, is nearly impossible under current conditions. And then this. Recent infusions of federal funds are of little assistance when there are no competent systems able or willing to employ those funds. Money arrived somewhere that could not absorb it. So gather the consequences the report names, because they run in more directions than people expect. For the accused, as of November 2008, there had been 223 post-conviction DNA exonerations. Even critics of those figures acknowledge that faulty forensic science has, on occasion, contributed to the wrongful conviction of innocent persons. Comparing pattern method results against DNA in the same cases revealed that some of these analyses, as currently performed, produce erroneous results. Backlogs keep innocent people wrongly charged in custody longer, and prosecutors usually have an advantage over most defendants in obtaining expert testimony. For victims and the public, every wrongful conviction leaves the actual offender at large. Crimes go unsolved because fingerprint databases cannot search each other, and the committee states it is possible some perpetrators have gone free because of those limitations, and possible some individuals were wrongly convicted for the same reason. Backlogs contribute to the release of guilty suspects who commit further crimes. Property crime victims may receive no forensic examination at all. For equal treatment, the quality and interpretation of evidence can vary unpredictably by jurisdiction. Daubert is applied more loosely in criminal cases than civil ones, and where death investigation lacks competent forensic pathology, both civil and criminal cases may be compromised, regardless of how good every other discipline in that county is. For public health and safety, the report calls the disconnect between what a medical professional would determine and what a coroner may independently decide and certify the weakest link in the process. Deaths in custody require an independence a third of the country does not have. Bioterrorism surveillance runs through these same offices, most of which operate at biosafety level 2 rather than 3. For public trust, the committee identifies what has been called the CSI effect. Jurors have come to expect forensic evidence in every case and to expect it to be conclusive. Research found viewers of forensic television were more critical of forensic evidence and yet more confident in their verdicts. And some prosecutors now believe they must make courtroom presentations as visually appealing as television. The concern raised is that this shifts how much credence jurors give experts, possibly resulting in a miscarriage of justice. And there is one consequence that belongs to DNA itself. Because DNA works, and works publicly, its authority attaches to the word forensic. The strength of the one validated discipline becomes borrowed credibility for the disciplines that have not earned it. Before the recommendations, the part that summaries leave out. The committee was explicit about the limits of its own knowledge. It could not size the problem. For the most part, it wrote, "It is impossible to discern the magnitude of these limitations, and reasonable people will differ on their significance." It could not assess the magnitude of the bias problem, because there was not enough effort in the field to measure. It decided early that a detailed evaluation of each discipline's scientific underpinning would not be feasible. It could not get a clear picture of how trial courts actually handle Daubert challenges, because many rulings issue without a published opinion and without an appeal. It receives no input on ink and paper methods and declines to offer a view on them. And it declines to estimate what any of this would cost to fix, calling that a matter for the Congressional Budget Office. A report that tells you what it does not know is doing something most reports do not. Then 13 recommendations. The first is the foundation. Congress should establish and fund an independent federal entity, a National Institute of Forensic Science. Its assigned functions include establishing and enforcing best practices, setting standards for mandatory accreditation and certification, funding peer-reviewed research, overseeing university program accreditation, teaching the legal system what these methods can and cannot do, and assessing new technologies before they spread. The committee set criteria for that body, rooted in science, tied to research universities and to state and local practitioners, not committed to the existing system, not part of a law enforcement agency, funded, independent, and prominent enough to push. Its verdict on that list? No federal agency currently exists that meets all of these criteria. It considered handing the job to agencies that already exist and ruled them out. The National Science Foundation has research capacity, but thin ties to forensic practice. NIST has standard-setting history, but a modest program and limited ties. And on the Justice Department, there was strong committee consensus that no existing or new unit inside DOJ would be appropriate, because forensic science must be equally available to officers, prosecutors, and defendants, and the potential for conflicts of interest is too great. Recommendation 2. Standardize the terminology used in reports and testimony, and create model laboratory reports for each discipline, required as a condition of accreditation. Recommendation 3. Fund the research that was never done. Studies establishing that these methods are valid, quantifiable measures of reliability and accuracy measured on realistic case scenarios across a representative sample of scientists and laboratories, quantifiable measures of uncertainty, and automation. Recommendation 4. Congress should fund the removal of all public forensic laboratories from the administrative control of law enforcement agencies and prosecutors' offices. Recommendation 5. Study human observer bias directly, including whether results change when the examiner knows the suspect's background or the investigator's theory of the case. Then write standard operating procedures to minimize it across every analysis that may be used in litigation. Recommendation 6. Build the measurement and validation tools with NIST and the scientific working groups. Recommendation 7. The one with teeth. Laboratory accreditation and individual certification should be mandatory. No person, public or private, should be allowed to practice in a forensic science discipline or testify as a forensic science professional without certification. And that certification must include written examinations, supervised practice, proficiency testing, continuing education, recertification, a code of ethics, and effective disciplinary procedures. Recommendation 8. Routine quality assurance designed specifically to identify mistakes, fraud, and bias. Recommendation 9. A national code of ethics, enforceable through the certification process. Recommendation 10. Build real graduate programs with scholarships to draw physical and life science students in, and fund continuing legal education for law students, practitioners, and judges. Recommendation 11. 6 parts for death investigation. Fund states to build medical examiner systems with the goal of replacing and eventually eliminating existing coroner systems. Fund forensic pathology research and training with loan forgiveness to fix the workforce shortage. Create a scientific working group for death scene investigation and post-mortem examination. Accredit all medical examiner offices. Restrict all federal funding to accredited offices or offices making measurable progress. And require that all medical legal autopsies be performed or supervised by a board-certified forensic pathologist. Recommendation 12. Achieve nationwide fingerprint data interoperability with baseline standards for the matching algorithms and a research agenda quantifying their error rates. Recommendation 13. Prepare forensic scientists and crime scene investigators for homeland security events, so evidentiary value is preserved and their own safety is guarded. The committee was candid about what Congress can actually reach. Most forensic practice is regulated by state and local government. Congress cannot amend state criminal codes, state rules of evidence, or state accreditation policy. What it can do is attach conditions to money, and it acknowledged the ceiling on that. State and local authorities have to be willing to enforce change for change to happen. Congress held hearings on the report. Members introduced bills. None of them passed. Senator Leahy introduced the Criminal Justice and Forensic Science Reform Act in 2011. He and Senator Cornyn reintroduced it in March 2014. It never received a vote. The House tried separately in 2020 with the Forensic Science Research and Standards Act. It was not enacted either. Recommendation 1 said no unit inside the Justice Department would be appropriate, because forensic science must be equally available to prosecutors and defendants. The Senate bill placed the new Office of Forensic Science inside the Office of the Deputy Attorney General. What was built instead came from agencies, not legislation. In 2013, the Justice Department and the National Institute of Standards and Technology created a National Commission on Forensic Science and an organization of scientific area committees to write standards. The commission met 13 times. On April 23, 2017, its charter expired and was not renewed. The Attorney General said the next steps would be developed by an internal committee that would not include independent scientists. The standards body remains at NIST. It posts standards to a registry, and the registry indicates that laboratories should consider adopting them. Consider. The National Institute of Forensic Science was never created. Accreditation and certification are still not required in order to testify. 17 years after the report, the answer is a voluntary registry. The committee's closing position was this: political and budgetary concerns should not deter bold, creative, and forward-looking action because the country cannot afford to suffer the consequences of inaction. And it added something that matters for anyone tracking what happened next. Each recommendation is a separate, essential piece. Even if the National Institute of Forensic Science was never created, it supported adopting the core principles in each of the other 12. The document is Strengthening Forensic Science in the United States, A Path Forward, from the National Research Council's Committee on Identifying the Needs of the Forensic Sciences Community, published 2009. Federal Record Number NCJ 228091. Produced under National Institute of Justice Award 2006-DN-BX-0001. The archived copy carries a notice that it was not published by the Department of Justice, and that the opinions in it are the author's and do not necessarily reflect department position or policy. Now, your number. The one you picked at the start. For how many times a kind of evidence should be examined before a courtroom trusts it? 14 laboratories, 21 examinations. That is the entire count in the survey. How close were you? Sourced, named, documented.